Dear 23, about 8 days late, but we're getting there. Safeguarding chess, playing the protection game. Safeguarding chess, how to win the protection game without looking guilty. Day 23 of 30. Safeguarding isn't just child protection, it's institutional self-protection. If you treat it like a moral accusation, you lose. If you treat it like a chessboard, you progress. Let me say something that's going to annoy you, and it should annoy you. It really should. In family court, safeguarding concerns doesn't mean someone has proved you're unsafe. It means the system has spotted a risk headline it doesn't want attached to its name. So the court does what every institution does when it's frightened. It doesn't chase the truth. It chases cover. And here's the bit they don't teach litigants in person. Safeguarding is a game of who looks safest to sign off. Not who's better, who's the better parent, no. Not who's telling the truth, no. Who's the safest for the court to be seen choosing. Today, I'm going to show you how safeguarding really works and how you turn it from a weapon used against you into a lever that moves your case forward in your favor. The real purpose of safeguarding language exists for one reason. It creates permission for restriction. Once the word safeguarding is in play, the system can justify supervised contact, supported contact, assessments, courses, testing, delay, you name it, gatekeeping. We'll review it later, and it can do all that without making findings, because findings create appeal risk. Findings create accountability. Safeguarding lets them say, we're not saying it did happen, so we're just being cautious. That caution is not about you, it's about them. So if you respond like it's like a normal human being, like outraged and defensive, furious, you look like the very thing they're managing, risk. So the single most important reframe. When CAFCAS or court says, we have safeguarding concerns about X, most parents hear, you're dangerous, but the operator here's demonstrate your reassurance on X and unlock your progress. That's the chessboard. Safeguarding concerns are basically a locked door. Each door has a key, and here's the move that changes everything. You propose the key before they demand it. Boom! Because the moment they impose on you, you look managed. But when you offer it voluntarily, you look insightful, cooperative, child-focused, safe to progress. That's not psychology. That's how decisions get signed off. Safeguarding chessboard, the moves. This is the sequence you're playing, whether you know it or not. This is what you're doing. Move 1. Concern raised, an allegation, a narrative, professional unease. Doesn't need proof, just plausibility. Move 2. Management proposed. Either you propose proportionate management, or they impose something heavier, broader, and slower. Move 3. Compliance demonstrated. The system rewards predictability, not righteousness. Compliance becomes evidence of safety. Move 4. Progression requested. You don't beg, you trigger review. You show the concern has been addressed and ask for measured steps forward. Move 5. The baseline established. What starts as temporary becomes the norm. So your job is to ensure the norm is moving upwards, not freezing. This is exactly the mechanism in the pack. 30-day court-ready plan. This is what I'm talking to you about, yeah? This bit professionals don't want you to know. Here's the dirty secret. Yeah, safeguarding is often negotiated, not discovered. Not in a corrupt way, in a structural way. Constantly trade reassurance signals. He did the course. She engaged with support. They used the app. They tested negative. They complied. They accepted boundaries. That becomes the currency that buys progression. And once you realize that, you stop screaming, I'm innocent, and start asking what reassurance signal unlocks the next step. How to turn a concern into a ladder. Here's some examples for you. Let's do this properly. Concern, proposal, review, progress. Concern, anger, emotional regulation, bad response. I'm not angry, she's lying. Operator response. To address any concerns regarding emotional regulation, I propose a time-limited step. I will complete, refresh a recognized program, and provide confirmation, and I propose supported handovers for 6 weeks with a review at the next hearing. Concern, lack of insight. The most dangerous label in family court, let's be honest, right? Bad response. I have insight, you're biased. You biased bastards. Operator response. I understand how the court could perceive X as concerning. I've reflected on how conflict impacts the child, and I propose measurable steps. Communication via the app only, and a short parenting communication intervention with review after 8 weeks. Concern, substance misuse. Bad response, I don't take any drugs. I'm not a fucking drug taker. Bastards. Biased. Operator response. To provide reassurance, I'm willing to undertake hair testing over an appropriate window, and I propose unsupervised daytime contact continues whilst results are awaited with a review upon receipt. Concern? Emotional harm, coercive control. Bad response. She's the abusive one. She's the abusive one. She lies. She lies. The operator response. I recognise the concern is serious, and my position is the allegation is not accepted, but I'm willing to accept safeguards that reduce friction. App communication, no direct calls, structured handovers, and a clear contact schedule that we can review in X amount of weeks. Notice what's happening. Yeah, notice what's happening. You're not conceding guilt. You're conceding reassurance. It's different. That's how you stop being treated as the problem and start being treated as the solution. You with me? You get that? Yeah. Now, here's what litigants destroy themselves with. Yeah. They offer reassurance that becomes a cage. They say, I'll do therapy indefinitely. I'll accept supervision for as long as they want. I'll do the course under the sun. I'll do every course they need. And the system here is great. They've accepted restrictions, no urgency to move. Let's just keep this right here. Your measures must be this. Specific, measurable, time limited, review triggered. Your language needs to be for an initial period of X weeks with review on Y date at the next hearing. That forces momentum. The operator template, you can steal this. When any safeguarding concerns are raised, your response structure needs to be acknowledge the concern exists in the system. Not that it's true, but it exists. Offer proportionate management steps, tie it to a child benefit, set a review point, request progression as logical outcome. Example script. I recognize there is a concern regarding X. While I do not accept the allegation as framed, I understand why reassurance is needed. I propose specific measure for specific time period with review at date and hearing. This maintains child relationship with me while providing appropriate reassurance to the court. That is safeguarding chess in one paragraph. Done. Boom. Final warning. Yeah, this is one that saves cases. This saves cases. Pay attention. Safeguarding hardens into status quo when if you let the system drift. Temporary becomes settled. Working, the child's routine, stability, all that sort of jazz. Yeah. When you're fighting uphill because the court's default is don't disrupt. Your job is to keep the case moving by proposing proportionate measures early, complying cleanly, triggering review, requesting the next step, repeating until you reach the target arrangement. And that is why I call this chess. Because the parent who thinks it's a fist fight loses. The parent who treats it like positioning wins. Today's practice task. Brought back. Pick each safeguarding concern in your case and write one operator proposal. Using this formula to address concern regarding X, I propose specific measurable action for a time limited period with review at date hearing. This will reassure Kafka's court while maintaining child benefit. The benefit of child benefit. Do 3 to 5 of these, keep them short, make them readable. You want to feed them back to me, send them to me an email, info at familycourtmastery.com. Let me know how you get on with it. Cheers. Boom. See you on day 24.